A father was assessed with a $10,000 penalty for failing to provide financial disclosure in a family law case in Ontario. Now, in the case, the mother experienced the father delaying disclosure, not being timely with it, also just not disclosing at all. And anytime she sought for him to produce a disclosure he agreed to produce, his answer would be take me to court and ask a judge to make me disclose it. So after a period of time, she brought him to court on another one of these instances where he wasn't complying with his disclosure and asked the court for relief for his noncompliance in the award of a penalty, a cost penalty, to deter this kind of conduct in the future. Now, the court found that this was an appropriate case in order to provide this type of relief because he was in breach of court orders and he had a history over the 6 years of the litigation of being untimely, delaying, and being chronically late with his disclosure, or sometimes even providing things the night before a hearing and just dumping documents on the mother. So the court found that this was a circumstance in which they should exercise their discretion and provide a penalty. Now, the court ordered that the father pay $10,000 as a result of his conduct because they said that this should be a deterrence factor so that in the future he stops doing this. Again, the case has been in front of the court for 6 years. This is a continued pattern. This wasn't the first instance of non disclosure, and the court was not accepting of his excuses. So, at the end of the day, the courts have the authority and the power to order relief to address non-compliance of disclosure related orders and in order to try to remedy this and deter people and have compliance so that people actually get the disclosure they're looking for.